Welcome to the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. I'm your host, Deepa Taylor, and today we're diving deep into a topic that's often surrounded by misconceptions and misunderstandings: family law. We'll be debunking some of the most common myths that circulate in the world of family law and providing you with the facts you need to navigate this complex field. Remember, the information provided in this podcast is for general informational purposes only and does not constitute legal advice. If you're facing a family law issue, we strongly recommend consulting with a qualified lawyer to discuss the specifics of your situation. In today's episode, we'll be tackling some of the most prevalent myths in family law. Whether you're going through a separation, considering a divorce, or just curious about the legal landscape, it's important to separate fact from fiction. Misconceptions can lead to unnecessary stress, poor decisions, and even legal complications. So let's get started by addressing these myths one by one and setting the record straight. One of the most common myths I encounter is the belief that if you move out of the family home during a separation, you'll lose your rights to it in the divorce. This simply isn't true. In Ontario, the matrimonial home is treated differently than other assets. Regardless of who moves out, both spouses have an equal right to the home, and its value will be factored into the division of property. Moving out doesn't mean you're abandoning your claim to the property. In fact, in some cases, leaving the home may be the safest or most practical option, especially if there's a concern for your well-being or that of your children. The key point to understand is that the family home is subject to equal division under Ontario's Family Law Act. This applies even if one spouse owned the home before the marriage. What's crucial is the date of separation. The value of the home at that time is what matters. So moving out doesn't diminish your financial stake in the property. Another widespread myth is that common law relationships are legally the same as marriages, particularly when it comes to property division. In reality, this is not the case. While common law partners have certain rights, they do not enjoy the same legal protections as married couples, particularly concerning property division. In Ontario, common law partners do not automatically have a right to an equal division of property upon separation. Unlike married couples, where the value of property accumulated during the marriage is split equally, common law partners must prove their entitlement to property through contributions made during the relationship, such as financial input or significant domestic work. This often involves complex legal arguments like trust claims, which can be both costly and difficult to prove. Some people believe that their pensions are protected and cannot be divided in a divorce. This is a significant misconception. In Ontario, pensions are considered a family asset and are subject to division just like any other property. Pensions accumulated during the marriage are part of the net family property and are divided upon separation. This means that the value of the pension accrued during the marriage must be equalized between the spouses. While it may feel unfair to some, especially if one spouse has worked hard to build up their pension, the law seeks to ensure both parties leave the marriage on as equal a financial footing as possible. A common misunderstanding is that paying child support automatically entitles a parent to parenting time with their children. However, the legal reality is quite different. Child support and parenting time are treated as separate issues under the law. Paying child support does not automatically grant you access to your children. Parenting time is determined based on the best interests of the child, not on financial contributions. It's important to remember that even if you're paying child support, if there are issues with access, these need to be addressed separately, potentially through the courts. Another prevalent myth is that if you owned property before the marriage, it's automatically exempt from division in the event of a separation. This isn't entirely accurate. While the value of property owned before marriage is generally excluded from the net family property calculation, any increase in its value during the marriage is subject to division. Additionally, if the property is a matrimonial home, its entire value is subject to division, not just the increase in value. This can come as a surprise to many who assume their pre-marriage assets are fully protected. We've covered a lot of ground today, debunking some of the most common myths in family law. Understanding the realities of family law can help you make informed decisions and avoid potential pitfalls during what is often a very challenging time. If you're facing a family law issue, I can't stress enough the importance of seeking personalized legal advice tailored to your specific circumstances. Remember, while we've provided some general insights today, every situation is unique, and what we've discussed might not apply directly to your case. That's why it's crucial to consult with a qualified family lawyer who can guide you through the process and ensure your rights are protected. For personalized guidance, please consult one of our family lawyers by visiting DivorceLawyers.ca. Thank you for joining me on this episode of the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. I hope you found this discussion helpful and informative. If you have any questions or need legal assistance, don't hesitate to reach out to us. Until next time, take care, and remember, when it comes to family law, knowledge is power.